everyone to today's webinar, Employee Discipline and Documentation. This webinar is being sponsored by River City Staffing, and we have with us Cindy from the company to speak to you.
Hi, this is Cindy Bunker, and I'm the president of River City Staffing, Accounting Solutions, and RCS Executive Search. This year, we are celebrating our 20th anniversary in business here in Sacramento, and just want to thank Sarah for allowing us to sponsor this event. And also, if you need assistance filling any positions in your organization on a full-time, temporary, or temp-to-hire basis, please give us a call and enjoy your webinar on employee discipline and documentation. Thank you.
Thank you, Cindy and River City Staffing, for supporting Sarah and its members. This webinar is being recorded, so everyone has been placed on mute to eliminate background noise. If you should have a question, we ask that you use the questions box located in the toolbar on the side of your screen. Recertification credits will be emailed this afternoon to those active on the webinar. Sarah has a few events coming up in the next couple months that we would like to share with you. Next week, we have our membership meeting on June 19th in Roseville. Registration is still open for that. August 8th, we have our fall PHR/SPHR study group kickoff meeting. Then let's not forget our annual conference is coming up in September. Registration is open, and I encourage you all to take advantage of our early bird pricing. It's now time to turn things over to Laura McHugh and Christina Hamilton. They join us from Dugan Law Corporation with more than 22 years of experience between the two of them.
Hi, good morning, everyone. I hope the sound is okay. My name is Christina Bucci Hamilton. I'm an attorney here in Sacramento. I've focused my practice on employment law, advice and counsel, and employment litigation on the defense side. I've been practicing for almost 6 years now. I love the opportunity to, get together and present on practical tips and best practices to avoid litigation in the first place. And I'll let Laura introduce herself as well.
Hi, everyone. My name is Laura McHugh, and I'm a partner here at Dugan Law Corporation. I have been practicing labor and employment law, representing companies for 23 years. And I'm happy to be here today and look forward to presenting to you all.
So throughout the presentation, I would love if you all would email over, or not email, but using the questions box on your right-hand side. Any questions that you have. Typically, I give this presentation live, and so it's a little bit more interactive, but I think that we can get the interaction if you want to use the question box. And we'll get to those questions towards the end. Okay, so why is documentation important to managing risk? As a litigator, what I think about when I am giving advice on how to document performance issues, how to document employee misconduct, is in a perfect world, defending a lawsuit 18 months down the road plus, what kind of documentation would I want in my file to be able to support a termination or to be able to support a disciplinary decision made? And so with that, we'll talk today about why it's important to managing risk, how do we properly document conduct, what is progressive discipline, and how do we use these topics as a training tool for our managers. So if you're in an HR role and you have managers who are responsible doing the day-to-day discipline, I want you to be able to go back and use what we talked about today to train your managers to have best practices so that when they're asking you to have their back on a termination decision or a more serious discipline decision, that the file looks the way that you want it to, and that you're comfortable with the risk spectrum, and that you can assess the risk based on what the file looks like. At the end of this presentation, I'm going to turn it over to Laura, and she's going to talk about how do we manage discipline when there's risk factors involved, particularly excessive absenteeism and employees on intermittent leave, and instances where a protected complaint arises in the course of doing performance management. So those types of items need to be handled a little bit with kid gloves, and Laura is going to talk about how best to do that. Okay, so the overarching principles today are, number one, document everything. There's no performance or misconduct conversation too small to document. And this doesn't have to be full-blown formal write-up every time, but just send yourself an email, keep a file in your email for employees, print it, put it in their personnel file, just some kind of paper trail so that if you're trying to recreate the wheel 2 years later, if a dispute arises, you have a paper trail of what you did and when you talked to the employee, and what the outcome was. Number two, be timely. Don't sit on an issue for a super long time. You want to address performance issues as they happen. You want to address misconduct issues as they happen. Otherwise, you lose the opportunity to gather all the facts when the issue is still ripe. Also, from a fairness perspective, when we're telling employees that there's a problem with their performance or that we're having misconduct problems, from my perspective, it's taken a lot easier by the employee if you're telling them when you have a problem and not 6 months later. So similar principle, be fair and consistent. We'll talk about when you're deciding what kind of consequence to give, to be retrospective about what kind of consequence you've given in other similar situations. From a employment litigation standpoint, that helps us be able to defend a termination when it's being called discriminatory. It also builds a better workplace when you're fair and consistent. You build trust with your employees. You know, they don't feel like they're being picked on, and you might get a better result if you're being fair and consistent. And number four, lead by example. That's pretty much self-explanatory. As HR professionals, you should be leading by example with regard to addressing discipline. You should be talking to your managers about leading by example with regard to their conduct. Okay, here are the basics. You want to address and document issues as they arise. Don't wait until you need to justify a termination. So many times I have clients call and say, I'm ready to terminate this person. We've had 18 months of issues nonstop. I've talked to them on numerous occasions, but then I drill down and I say, well, when did you talk to them last? You know, did you give them a consequence? Did you tell them they had a time frame to improve? Many times the answer is, I don't remember when I talked to them last, but I know I talked to them multiple times. You know, no, I didn't tell them what I just told you about how serious the issue is. I'm going to tell that client that from a practical perspective, you know, the employee is going to be surprised by that termination if you are approaching them for the very first time to tell them about their 18 months of issues when you haven't addressed it head on at all in those 18 months. So you want to be addressing and documenting issues as they arise. The whole point of employee performance management is to recoup your investment in that employee. As you know, it takes a lot of time and money to hire and onboard someone. You should be wanting them to succeed. And so waiting until the employee is beyond help to address their performance deficiencies is not a great idea. It's one of the reasons why I think an annual review is not enough. An annual review is great as kind of a catch-all tool, but you really should be addressing deficiencies more frequently than that. Otherwise, you lose the opportunity to kind of rehabilitate that employee and help them be the best that they can. So that kind of flows into my next point. You want to document and address issues during the probationary period in the same way as you would a long-term employee. Many organizations have a probationary period. What I have seen is that employees who are in their probationary period are given a little bit more short shrift as far as, you know, tolerance for performance management, which is fine, but you know, that doesn't mean that you should ignore risk factors or ignore red flags just because the employee is in the probationary period. From a legal standpoint, you don't get any more legal protection when you're making a termination decision for an employee who's in their probationary period versus making a termination decision for an employee that is a long-term employee. That doesn't mean that the discipline, consequence, or result should be the same. My only takeaway point there is that you need to have a paper trail the same as for an employee in the probationary period, the same as you would for an employee who's a longer term employee. What do we include in documentation? I acknowledge that many of you perhaps have your own forms. If you're a smaller organization, or if you're an HR professional who's trying to get the HR department in better shape, you may not have a form. So whether you have a form or not, these are the basic items that you want in a piece of documentation for performance management or for addressing misconduct. You want to focus on the facts. Who, what, when, where, why, how, those basic journalistic questions. You want to acknowledge the poor performance or the behavior or the policy violations, be as specific as possible. If there's a policy violation, point to the policy in the handbook. If there's a performance metric that is not being reached, point to where the performance metric was originally communicated so that the employee can hearken back to, you know, where is this discipline coming from? You want to give an expectation and a deadline for compliance. For example, you know, if it's an attendance problem, we need you to have better attendance in the next 60 to 90 days. We're going to be looking at your attendance so that they know you have your eye on them. Or if it's a performance metric, we need you to have your numbers up in 60 days. And we'll talk about this in a minute, but you also need to be prepared to follow through. So for your part, don't pick a compliance period that you're not willing to follow up with and take a look at. You want to tell them the consequences for noncompliance. You need to put a date on the piece of paper. I can't even tell you how many times I've received an employee file and there's there's notes of conversations, but no date. And so we have, no idea 2 years later what came first. You want the manager's name on the document. If the employee gives a response, that should be noted. And there should be a place for the employee to sign. I will say that the last 2 points are not essential, but if you're going to create a form, those pieces are helpful. Many times the employee will say, well, I said in my performance management meeting X, Y, and Z, and while the manager documented all of the things that he or she said, there's no documentation of the employee response. I should also note that any and all of that can be done also in a follow-up email to the employee. I don't really care how you do it. You should just have some kind of system for doing it and make sure you communicate that to your managers so that organization-wide you have a streamlined system for keeping track of employee disciplinary conversations. Okay, what don't we want to include? We don't want to speculate about facts. We don't want to make conclusions without any factual support. We don't want to use emotion, innuendo, supposition, all these kind of squishy, non-facts-based comments are not necessary in employee documentation. And in fact, it can make your lawyer's job harder on the defense side when there are all of these other kind of non-essential comments that a plaintiff can hang on to in attacking a termination decision. You want to leave out personal opinions about the employee or the conduct. For example, John is irresponsible. That may be the case, but you can say the same thing in using objective facts. And the last one is kind of a gimme. Do not make references to protected classes or protected activities. Obviously, you're not going to say John, the disabled employee, is irresponsible, or at least I hope you wouldn't. But what I mean by that is particularly when you're dealing with someone who has excessive absences, you're going to want to be careful about addressing those excessive absences. You don't want to glob onto absences that are taken pursuant to FMLA intermittent leave, for example. So that's what I mean by omitting references to protected classes or protected activity. So the way that we address conduct in the workplace really depends on whether it falls in a poor performance category or a misconduct category. The response and probably the amount of patience that you have with the employee as far as patience for rehabilitation is going to be different when the issue is poor performance versus misconduct. So looking at poor performance first, we're talking about completing job requirements poorly, such that it's creating a burden on other employees, conduct that's undermining the employee's value to the organization. Maybe they do their job, but not in a way that's efficient. And behaviors that are repeated over time. So maybe we're talking about something that isn't a problem the first 2 times, but it becomes, a hallmark of that employee's particular, we'll say their file. You see the same thing over and over and over again. That can fall under the umbrella of poor performance. So some examples, an employee who's always late or who's frequently late. Maybe an employee who has the Monday, Friday flu. An employee who leaves without notifying anyone. They just kind of go MIA at 3 o'clock on Friday every Friday. Again, maybe that's okay some Fridays, but not every Friday, right? Or maybe you have notification procedures that they're just ignoring. Employee who can't seem to work cooperatively with peers. Employee whose work is late or incomplete. Employee who just doesn't do anything very well or satisfactorily. It's just consistently below par work. These are all classic performance issues that can be addressed. You can usually fix performance issues if you catch them early. You know, sometimes not, but if you're seeing these things, it's important to catch them early and to address them early. So when we're dealing with poor performance, as a litigation attorney, I'm looking for progressive discipline. I'm looking for a history of conversations about the poor performance. I'm looking for you know, is this employee on notice of the deficiency? When did they become on notice? You know, did you tell them for the first time last week and you're asking for a blessing to fire them today? Or has this been going on and on for 6 months and they've got at least 3 write-ups in the file? I'm looking for whether training and the opportunity to improve the performance was given to the employee. Note that these are all best practices. You can absolutely terminate someone for poor performance, you know, as long as there are not other illegal reasons that are sprinkled throughout and it's masked by poor performance. But if you're truly terminating someone for poor performance, you can do that, but you are lowering your risk and you are putting better practices in place if you have a policy of following some sort of progressive discipline. As a matter of practice, I do not recommend that you have a formal policy of progressive discipline that's lockstep. Of course, that's going to be different in a unionized environment. So if any of you are HR professionals in a union environment, you're going to have different standards that apply to performance. But when we're talking about a non-unionized environment, there's no employee contract in place. Progressive discipline lockstep is not required. But some sort of informal policy of progressive discipline is a best practice. And so if you look to your employee handbook, you'll probably see a policy that says something to the effect of, we use progressive discipline, but reserve the right to proceed to termination upon a first offense. And again, that's fine depending on the circumstances, but the takeaway best practice for today is what I'm looking for when I'm assessing risk, is whether or not, 1, the employee was put on notice, 2, whether they were given the opportunity to improve their issue, and 3, what does the paperwork look like, documenting all those steps. I want you also to be consistent in the discipline that you're doling out. You can get into legal issues if you're inconsistent. So one example I like to use is you fire someone for poor performance. Let's say it's an employee who hasn't been there for very long, and they made a pretty egregious mistake, and so you went straight to termination without any intermediate steps. And then the employee sues you. And they're suing for discrimination, and they said, you know, I got fired after I made a mistake, but I know that my white colleague made the same mistake 6 months ago, and they had the same amount of tenure as I did, and I know that employee got put on a PIP instead, a performance improvement plan, and they just fired me. Those are enough facts to state a claim for for discrimination. We're trying to avoid that. And so be mindful of what you have done in other situations with similarly situated employees who have messed up the same, for lack of better words. Okay, so now we'll move into misconduct. Misconduct is much worse than poor performance. Usually it's a single incident. Employee does something that's contrary to the nature of the job or to the organization's rules of conduct. Sometimes we can handle that with progressive discipline, but depending on the severity of the conduct in question, you may want to consider giving a first and final written warning. You know, skip the verbal counseling, skip the addressing an email, and do it formally. Depending on the misconduct, you may go straight to termination. Again, it's perfectly fine to do that, but I would want you to be cognizant of what you've done in similar situations in the past so that you're being fair and consistent. So here's some relatively straightforward examples of misconduct: threatening violence against a coworker, stealing, dishonesty. I would also add conduct that is clearly sexual harassment, bullying. Those are items where you don't want to fool around with 3 warnings for a person who keeps threatening to punch his coworkers. Ironically, I have a picture of a man stealing a stapler. Technically misconduct, yes, but I mean, taking home office supplies, not sure, depending on the workplace. I suppose that could rise to the level of termination, but if you're going to terminate an employee who's stealing the red stapler, you should also be prepared to terminate the employee who's stealing all the good pens, in which case I would have been fired by now. The reason why we deal with misconduct differently is because there's no training course to teach someone not to steal, or there's no training course to teach someone not to threaten to punch their coworkers. These are things that employees are reasonably expected to know, and so it makes sense to proceed to a higher level of addressing that conduct, and to proceed with harsher discipline without prior warning. So going back to performance issues, what's the lowest level of warning that you can give to an employee? It's a verbal warning. Many organizations will have, you know, some written form that's a confirmation of a verbal warning. You may have been giving verbal feedback that's not necessarily couched in terms of a warning. Even if you're not couching your feedback as a, you know, air quotes warning, you still want to give that feedback. I've heard over the years some concern that, you know, what the employee is doing performance-wise doesn't really rise to the level of a verbal warning. I don't want to ratchet it up. You should at least be giving some kind of neutral feedback at the first sight of a performance deficiency. And if that's not working, then you can proceed to, you know, a more stern verbal warning, a verbal warning that is followed by, you know, formal written documentation of the verbal warning. The point here is that even when you're giving a verbal warning, you still want to document those verbal warnings and the verbal feedback. Again, a simple email will suffice. You can send an email confirming to the employee. You can send an email confirming to yourself and print it and put it in the employee file. Just some kind of paper trail, because I guarantee you that you are not going to remember all the times you gave verbal feedback to an employee when I'm asking you about it in 18 months. But you will say, yeah, I know I addressed it with them at least 3 times or what have you. If you have notes in your desk drawer, notes in their file, some kind of contemporaneous documentation of when you talk to the person and briefly what you said, it goes very far in being able to recreate the circumstances leading to usually what you're consulting your counsel about a termination. So you've given feedback, you've talked to the employee, you've tried to be constructive with them, and you're just not getting any results. At that point, you can move to the next step in your disciplinary structure, whatever that is. So if that next step is a written confirmation of a verbal warning, if that next step is a first verbal warning, whatever it is in your organization, if you are not getting results from your prior addressing of the issue, you should move to the next step. And you know that it's time for the next step if in the course of giving your verbal warning or giving your verbal feedback, you have given metrics for improvement, and it's something that you can measure, or you've given, I'm going to check back in with you, employee, in 30 days, and in 30 days you've seen no improvement. If you're not seeing that improvement, you need to give the employee a sense of urgency. And the most effective way to do that is to have a more formalized writing. If you're being informal, and you don't ratchet up your performance management at all, I tend to think that employees get numb to that feedback, and you want to get to a place where they're paying attention to what you're saying again. And so that's when you ratchet up and move to the next step. You want to impart to the employee, okay, we've tried XYZ, it's not working. Maybe you've improved a little bit, but you're still not meeting the metrics that we've set. Your compliance is now urgent, and to show you this, we're going to give you a piece of paper to sign. So back to misconduct, you're probably going to skip your verbal warning and go straight to a written warning. Again, you want to be consistent with that, but essentially with misconduct, because it's something that shouldn't need to be performance managed, employees, again, shouldn't be put on notice that they can't threaten to punch other people. You can go straight to a written warning, and I would argue that you should go straight to a written warning. Again, you want to impart the seriousness of misconduct and the seriousness of your response, as opposed to how you would respond for, a performance issue. And you want to impart that, this cannot happen again. Your compliance is urgent and required. We talked a little bit about probationary status a few slides ago. You can take that into consideration with misconduct. You might treat misconduct differently for an employee who's only been there 3 months versus an employee who's been there 10 years. But again, that probably depends on the type of misconduct, right? And that goes back to being consistent. Try to keep notes and try to keep a file of at least in your memory, a Rolodex of the types of misconduct that you have encountered and how you've dealt with it in the past, and make sure, you know, what's good for the goose is good for the gander, basically, so that you can defend that termination if you get slapped with a lawsuit saying it was a discriminatory disciplinary action. So written warnings. You can, but are not required to give multiple written warnings. You can give a first written warning and a final written warning and have the next action be termination. It doesn't really matter how you do that, but you should be consistent. And again, anytime that you're doing a written warning, you want to be detailed in the description of the issue and the expectations as to improvement. The reason for this is not to put the employee on notice of the issue and the expectations, because you probably did that verbally when you delivered the paperwork. But the reason for the detail and the expectations is so when I'm asking you about it in 18 months, you're not going to remember it if you don't write it down in sufficient detail the first time around. So it's a risk management strategy to be detailed on the front end. Okay, so how do we effectively use our forms or effectively use whatever system you've put into place to document performance issues, to document misconduct? Rule number 2 is be timely. Do it right away. Don't sit on the issues for 6 months. Don't wait until the annual performance review rolls around in January. When you are doing your documentation, you want to be detailed. And the most important piece is, what exactly am I having a problem with? What are you doing, employee, that I have a problem with? Where appropriate, you want to include witnesses to the problem behavior. You want to include documentary attachments to the written write-up that you can refer to. I want you to stray away from generalized statements like poor attitude or efficiency needs improvement. You can't really measure that, and it's hard for the employee to know exactly what they're doing so that they can improve it. When you're getting to the step of a written write-up, you should refer back to informal feedback or discipline. If you're timely documenting, like we've suggested, for example, if your new practice is to send yourself an email every time you have kind of an informal conversation with an employee, you should be able to harken back to that. And if you send the email to the employee, you can reference, I sent emails on this date, this date, this date, and this date. This should not be new to you. I haven't seen improvement, and therefore this is why we're doing a formal written write-up. You want to make sure that you include a desired outcome on your written write-up. What does the employee need to improve? What behavior do you want to see at the end of whatever time frame you've decided that would be satisfactory improvement to you? To do that, you should use SMART goals. Hopefully this isn't the first time that you've ever heard of this acronym. I used to think it was a little bit corny, but I actually think it's quite effective in terms of employee management. And it's something that you can memorize and use. When you're scribbling a write-up quickly on a Friday just to get it documented, You should refer to the SMART goals and make sure you have each of those boxes checked to have, you know, an effective documentation of written discipline, and it'll help you get the outcome that you want. Again, it's expensive to onboard and train an employee, and the goal should really be to improve performance. I realize that sometimes you really need to performance manage someone out of a position, but most of the time your goal should be really to see improvement and to retain the employee. So performance improvement plans, they are really helpful, particularly when you use them early on in a performance problem. But the caveat is that you should use a PIP in good faith. You know, don't identify someone as a problem employee that you're ready to performance manage out. You've never used a performance improvement plan with any other employee before. And so you're going to use one now and put them on a 2-week timeline for turnaround. That's just not going to work. And if litigation arises from that particular employee, it's not going to look great that you're using a performance improvement plan for the first time, and that the metrics for measuring compliance with that performance improvement plan, if they're unreasonable, it just looks like you're doing it in bad faith. You should really be using the performance improvement plans as a tool to facilitate and track the employee performance. You can use it as early as after you give a verbal warning. You can use it as late as, you know, look, as a last best and final effort here before we terminate you, we're going to put you on a PIP. That's fine too. Again, you should be consistent about when you're utilizing that as a tool, but it can really be used at any point in the disciplinary process. A great time to use it is after the annual performance evaluation. It kind of sets the employee up for a structured lockstep improvement model starting the next observation year. But again, whenever you're using it, just use it in good faith, and really view it as a tool and follow up. Don't do a performance improvement plan, say you're going to check in 90 days and then they don't hear from you one way or the other until their next annual performance evaluation, or you're telling them for the first time 9 months later that they did not comply with their PIP. It can be a very effective tool, but it definitely requires some hands-on from the manager. Okay, and termination. It's the last step in your process. As you all know, employment is typically at will, but when you're making a termination decision, you need to double check that there's no contract in effect. You can terminate for any reason or for no reason, but not for an illegal reason. Again, the best practice is that you have some sort of paper trail before you're making a termination decision. As an HR professional, you should be reviewing the file to assess risk factors prior to making the termination decision, and you should be looking for that backup of why you're terminating someone, so that you're always having a legitimate business reason for the termination. And that's going to be particularly important when we get into employees who have a red flag present. Examples of those risk factors are going to be employees who are recently on leave, employees who recently made a protected complaint, or disabled employees with whom you're engaging in the interactive process. with all of that said, sometimes the first offense may justify termination, and you just need to be aware that that's not always your best decision, right? So I'm going to turn it over to Laura. She's going to talk about handling performance improvement and misconduct in the context of employees where there's a red flag, such that you should have extra care with that employee.
Okay, hi everyone. Christina just gave you a great overview of general discipline and documentation issues, and as she just mentioned, I'm going to talk about the trickier disciplinary situations that arise when an employee is on a protected leave. It's very difficult to manage and take action when the employee is on a protected leave, as you probably all know. Some of the common protected leaves are the California sick leave law, which as of 2015, all California employers are required to provide paid sick leave. Then, of course, for you bigger employers, there's the FMLA and CFRA that applies to employers with 50 or more employees generally. And then there's also the California New Parent Leave Act, which applies to employers with 20 or more employees. And that allows for baby bonding time when you have a baby, adopt, or have a foster child. The pregnancy disability leave applies to employees who are truly disabled by pregnancy, and they're entitled to up to 4 months off of leave time. Now, of course, there are other leaves that are not mentioned on the slide: military leave, domestic violence, crime victim leave, school appearance leave, bone marrow donor leave, etc. But the ones we see typically in our practice are these more common ones. I just had an issue come up in this area just yesterday, and it's a great illustration of how often this can come up and how common these issues are, and in what context they can arise. I had an employer call me yesterday wanting to terminate an employee who was on the radar for termination for performance issues. At the same time, the company lost a lot of funding and is trying to revamp and save the company, and they did an analysis of who they should let go, and they thought it should be this woman. They were just ready to pull the trigger, and she told them she was pregnant. So they called saying, what do we do? What's our risk? And we had to talk them through that and come up with a strategy to make sure that the reasons they were terminating were going to pass muster and couldn't, result back to a pregnancy disability claim. In that particular case, they had many employees out on a pregnancy leave, including this employee previously. We were able to look at it and come up with a bona fide plan of, let's not look at her performance issues because you didn't document them. Let's just look at your financial situation and maybe look at this as a layoff. But again, it got kind of tricky. If they had went ahead and fired her, timing wise, she would have had a problem. They would have had a problem because of her announcing her pregnancy. Okay, so looking at attendance issues, California sick leave law complicates attendance issues. California employers cannot have attendance policies that count sick leave absences or tardies against the employee. This violates the California sick leave law. Also, you cannot have what are called neutral max absence policies, basically a policy that says, flat out, if you have 10 absences in a month, you'll be terminated, or if you have 10 tardies, in a 3-month period, you'll be terminated. You have to take into consideration the reason for the absences and then find out whether they are protected or not. So the takeaway is that before you discipline someone for being tardy or absent, you really need to assess whether sick leave was used or another protected category might apply. I will add one thing here. Of course, if the employee has truly exhausted their sick leave, they have no more sick leave on the book for the year or the relevant period, then you can, depending on the circumstances, go ahead and discipline them because it's not going to impact the sick leave and get you in trouble with the sick leave law. Okay, so let's talk about intermittent leave and how that plays into attendance issues. This happens under the FMLA, the CFRA, and actually also the pregnancy disability leave laws. So what are you required to do? You're required to grant leave when medically necessary. And oftentimes this intermittent leave is unscheduled. So for example, you might have an employee suffer from a serious bout of anxiety or depression. The symptoms come on quickly and they call out last minute. You would generally have to allow them to take that time off and then ask for certification and then go through the process to see whether that's a valid request for time off. But it's better to err on the side that they actually have a bona fide issue and that you want to allow them the time off to deal with it. Intermittent leave, of course, as with other leaves, are prone to abuse. And, you know, Christina mentioned the Monday, Friday flu. If there is abuse, it's okay to call out the patterns of abuse, but you have to be very careful. So for example, if someone is on an FMLA leave, and it's intermittent, and they're always off on Fridays or leaving early Fridays, you have the right as an employer to look into that for a possible abuse issue, but you have to be very careful, not jump to conclusions, and really look for the facts supporting your position that they might be abusing the policy. Okay, so in terms of documenting the intermittent leave, you want to document the reason, the date, the day of the week, and the time of the day, if applicable. Again, you may not discipline an employee for an absence that is for a qualifying reason or protected leave. Again, that accepts abuse situations which have to be treated carefully. When you do give a written warning regarding ongoing attendance issues, do not consider or refer to protected absences, sick leave, FMLA, pregnancy, etc. Okay, can you ask for medical recertification? Yes, you can if the circumstances described by the existing certification have changed, or if you receive information, for example, from an employee's coworker or your own observations that the stated reason for the absence is not valid, and you question the continuing validity of the certification. So, of course, caution, always attempt to independently verify information received from coworkers before taking action or requesting recertification for suspicious circumstances. In terms of appointments for intermittent leave, you can ask the employee to schedule in a way that least disrupts your operations. Again, you want to communicate with the employees about the frequency of the treatment, the office hours of the healthcare provider, and the ways the employee may be able to alter the schedule to cut down on disruptions. Now remember, when you are looking at these issues, you're looking for medical work restrictions that prevent the employee from performing their job duties or their essential job functions. But you cannot ask the nature of the employee's medical condition that violates California privacy laws. Okay, terminating employees on leave. This is a huge area that we've gotten calls over the years on. What happens when someone's on a leave and you discover something that makes you want to terminate them? I'm sure many of you have had this situation where an employee goes on a leave of absence and someone has to step in and do their position, their work, and they find deficiencies or misconduct. The low level of that, for example, would be the person's not properly filing documents or completing assignments, and they're kind of buried away in their desk. The extreme would be, for example, embezzlement. So what do? First thing you want to do is document the issue when it's discovered. But don't go for looking for issues just because the employee is on leave. You can't do a witch hunt, but if you have bona fide concerns, document them. Number two, you should plan to address the issues immediately with the employee upon the employee's return to work. Now, how do you address this? This might be a verbal warning, a written warning, a PIP, but it also might be a full-blown investigation, a thorough investigation where you talk to the employee, get his or her point of view, you get witness statements, you get witness interviews, Based on all of that, then you can come to the conclusion that this either is or is not a terminable offense. If it is, option 1 is to terminate while on leave, but you only want to do that if you're 100% certain that this misconduct occurred and it truly is a terminable offense. The other option is to wait till they return to address and terminate, and like I mentioned before, possibly investigate. In any event, it's essential to have the complete documentation and make sure that when you are dealing with the situations, you are treating people equally, as Christina mentioned earlier. You don't want to selectively enforce rules or policies. Okay, so let's talk about handling red flags. Sometimes an employee will raise some type of complaint in the course of the disciplinary process. For example, I had a case recently where an employee was being investigated for misconduct and he knew he was in hot water, and he suddenly raised a bullying complaint. And he said that one of his coworkers had been bullying him, and part of the bullying was this complaint by this coworker that was leading to his discipline. So what to do in a situation like that? Well, in this particular situation, the employer wanted to go ahead and entirely disregard the bullying complaint because they were so focused on disciplining him for what had happened. And that's the big no-no. You have to go ahead and respond to the complaint made by the person who engaged in the misconduct. It could be a false complaint by this person who's just trying to inject themselves into a protected category to delay or get in the way of a maybe impending termination, but it might be a bona fide complaint. And if so, you have the duty to do the full investigation and come to an outcome and then act accordingly, not only with regard to the bullying complaint, but also with the underlying investigation. And by the way, if that employee's complaint was entirely false and you can't corroborate it and you have proof that it was false, you can discipline that person for making that false bullying complaint. Okay, more red flags, suspensions, terminations. How do you handle those when there's protected activity? Number 1, this brings us back to documenting everything. You want to make sure that the documentation of the issues exists prior to the protected activity. In terms of employees returning to work or not returning to work after their scheduled date, what do you do if someone says to you, you know, my 12 weeks of FMLA leave is ending, but I'm not returning to work. Can you just fire them? That's the question that comes up all the time. And the answer to that is it depends. You can't just fire them just because they're not returning to work. You have to consider whether they may be in a protected category. And a common one is disability. Maybe the person is just not ready to return to work and they need more time. And if that's the case, you have to engage in what's called the interactive process in good faith with the employee and determine whether or not they can perform the essential functions of their job with or without a reasonable accommodation. And again, a reasonable accommodation might be just to extend their leave of absence. You don't have to do it indefinitely, but you might have to provide that as the accommodation. It might be reduced schedule or other accommodations that come up during the interactive process. So this brings us to questions. Did you want to chime in?
I saw a couple of questions come in. My panel is being a little funky. Let's see if I can read them.
If you hit the little box with the arrow, it will make it bigger for you.
Okay. Okay, so here's a question. How would you suggest we approach a situation when an employee notifies the employer that he and his girlfriend are expecting a baby any day now? Following day, the employee calls off because the girlfriend lost the baby. Then the employee finds out that none of it is true and the girlfriend was never pregnant.
Well, the first thing you want to do is investigate and corroborate and find out if any or all of this is true. If it's true that they were never pregnant and they lied, they're not protected. And let's see, was the girlfriend also an employee? Well, regardless. Okay, so I'm going to assume that the non-pregnant person is the employee. If you find out that that non-pregnant person was lying, then you can discipline them for that.
Someone asked if the slides would be emailed. Yes, they will.
Here's another one.
There we go. If the employee is not on a protected leave and they are out for anxiety, depression reasons, they are covered under the ADA, so you can't discipline them anyway. Can I require them to provide doctor's notes taking them off work each time they are absent? So correct. If they are not eligible for FMLA or CFRA, either because you're a small employer or because they haven't worked the requisite amount of hours, yes, they are covered under the ADA and the Fair Employment and Housing Act. You have an obligation to engage in the interactive process and make reasonable accommodations.
Unless it causes an undue hardship. But you can't take that whole interactive process lightly and just unilaterally decide it's an undue hardship. You really have to engage with the employee, get medical documentation, sit down and talk with them, ask them what they think options are for accommodations, and go from there.
I think you're going to have a problem requiring them to provide a doctor's note every time they're absent, particularly if they're taking California sick leave for their absences, and you cannot ask for a doctor's note as a contingency for allowing them to take sick leave. You can ask for a doctor's note to certify a disability. So typically my practice is at the beginning of that interactive process when the employee says, you know, I've had a bout of anxiety, I couldn't get out of bed this morning. You can ask for a doctor's note certifying that they have a disability. You're not entitled to a diagnosis, but you can have the doctor certify what restrictions, what proposed accommodations they're asking for, but I wouldn't recommend it, just generally speaking, to ask for a doctor's note or demand a doctor's note every time they are absent.
Yeah, that's actually probably illegal to do that.
So those look to be like all of the questions. We really enjoyed taking the time to present to you this morning. I hope that it was helpful and that you can go back to your organization and build in some best practices both in your own department and with your managers so that you can manage your risk in dealing with employees and have better documentation practices. So we'll sign off now. Thank you again, everybody. That was great.
Yes, thank you.
Thank you, Christina. Thank you, Laura. Have a good day, everyone.